Welcome to our first estate planning webinar. First, we're going to begin with our traditional land acknowledgement. So as CEO for Children's Health Foundation of Vancouver Island, it is my honor to acknowledge that we deliver services across our beautiful island in the Gulf Islands, and we pay tribute and honor the relationship that the Indigenous communities, Nuu-Chah-Nulth, Kwakwaka'wakw, and others who make this their home. And we are thankful that they allow us to do the work that we do. So welcome. I'm going to begin first by telling you a little bit about who we are. Children's Health Foundation, we invest in the health of island kids, and we've been doing that since 1927. Our mission is, and our vision is, that all island children have access to the health care that they need. And we have been supporting island kids since that time. Many of you may not know, but we are 100% donor dollar funded, and we receive no government support. We do two main things, one of which is our impact is measured through our homes away from home. One in Victoria, Janice Place, and the other Kualayu House in Campbell River. Last year, as you can see, the wonderful support that donors provide, 548 families stayed at one of our home away from homes. The average stay was 7 nights, and families stayed a total of 3,947 nights combined. Our longest stay for a family was 110 nights. So you can imagine that. Quite a epic stay, and the stress and strain, I'm sure, was immeasurable. The other program that we support through our donor dollars is our Bare Essentials program. Last year, 874 Bare Essential applications were funded, and this is direct to family support. Of that, 776 health-related trips were funded by the Bare Essentials program. 274 healthcare professionals or referring professionals help us to connect directly with families across our islands. And 250 plus pieces of specialized equipment to help kids access healthcare that they're needing. What does all of that mean? It means that families can stay closer to their children when they need to be close, and that reduces health-related costs for travel and equipment, and obviously reducing those financial burdens provides less stress for families and a sense of belonging and increased peace of mind for those families. So thank you to everybody who supports children and island kids, and I'm going to hand it over to my colleague, Amgad.
Thank you so much, Veronica. Hello, everyone, and a warm welcome to you all. We truly appreciate you taking the time to join us today, and I hope you find this webinar both insightful and valuable. My name is Amgad Zaki, and I have the privilege of serving as the Legacy Giving Officer at the Children's Health Foundation of Vancouver Island since January 2024. And wow, what a year it has been. I feel incredibly fortunate to be part of such a lovely team working to make a meaningful difference in the lives of island kids and families. Before we begin just a quick note that some of the information that we will be sharing with you today, we're going to be putting it together, and we'll be sharing it with you after the webinar. So stay tuned with more information in case you would like to revisit any of the insights shared today. Also, before I pass it on to our guest speaker, I want to share a bit about a special group of a special group at Children's Health Foundation of Vancouver Island, our Legacy Circle. So this circle is composed of kind-hearted donors who have made the incredible decision to leave a gift in their will to support our work. Their generosity ensures that we can continue our vital mission for generations to come. And what's remarkable about this group is that many of these individuals have been long-standing supporters, contributing not just through these legacy gifts, but also by sharing their time, talent, and treasure. They really play a crucial role in creating a lasting impact on the health and well-being of island kids across Vancouver Island and the surrounding island. So to show our appreciation, we invite all Legacy Circle members to enjoy some special benefits, including priority invitations to our foundation's events, exclusive engagement opportunities with the foundation and fellow donors, also regular updates on the impact of their generous gifts, as well as, of course, recognition if they wish to inspire others and celebrate their generosity. It's truly an honor to recognize these incredible individuals who are helping ensure that island kids receive the care and support they need for years to come. And this is an example of a legacy donor, Victoria resident Selwyn Wong, who has been a dedicated supporter of a Children's Health Foundation of Vancouver Island since 2012, when he was inspired by the construction of Janice Place, our Victoria home away from home. Although he does not have children of his own, Selwyn is passionate about ensuring all the children have access to essential health care, and his commitment led him to leave a legacy gift in his will, helping to reduce barriers to care for future generations. And as Selwyn puts it, in a perfect world, I'd love to see no child ever needing medical or psychological or emotional assistance, but that's never going to happen. And the next best thing is to make sure they're taken care of wherever they are. So his gift reflects his really deep belief in giving back to his community and ensuring that children and families get the support they need when facing health challenges. Now it is my pleasure to introduce our guest speaker for today. Sarah joined Farris LLP as an associate with the firm's private client services group in 2023. Her practice focuses on estate planning, estate administration, and trusts. Sarah obtained her Juris Doctor from Michigan State University College of Law in 2018. During law school, she attended the summer law program in The Hague, Netherlands, studying international criminal law and war crimes, and was awarded the Jurisprudence Achievement Award for the highest achievement student in agricultural law. Before joining Farris, Sarah articled and practiced as an associate in the areas of estate planning, estate administration, and real estate law at a small Vancouver law firm. Thank you very much, Sarah, for your willingness to share your expertise with us today and shed some light on this important subject that many of us often avoid. Following Sarah's presentation, there will be a Q&A session, so I encourage everyone to write down any questions or comments you might have in the chat box at the bottom of your screen. And if we have time at the end, we'll do our best to address them. With that said, I will pass things over to you now, Sarah.
Okay, thank you so much for the introduction. Hopefully you can hear me okay. Good, okay, great. All right, so let's get my slides up here. So as Amjad said, we're going to do kind of a general estate planning 101 introduction today. So I'll just get to my overview slide here. Okay, There we go. Okay, so what we're going to start with today is planning for during your life. So we're going to look at powers of attorney and representation agreements. And then we're going to look at planning for after death. So generally kind of just speaking about your will, essential parts of a will, opportunities for charitable donations, and then some other pieces of your will and protecting your estate. And then we're going to briefly look at what happens after death. We don't have a ton of time to do that, but we can kind of just go through some of the steps in that estate or probate process. And then we'll go over some key tips, and then we'll have time for questions. Okay, so if we're going to look at planning during life, we'll just wait for that slide to change. But I can just start going on powers of attorney. So powers of attorney are documents that you will sign in which you would appoint somebody to handle your legal affairs, your financial affairs, and then also to deal with real property. So like a common use of this would be maybe you appoint your spouse or a child to assist you with any like banking decisions, investment decisions, or paying bills, or maybe you would need them to assist you with selling property. Are you guys seeing the power of attorney slide? It's not working for me for some reason. Sorry about that. There we go. Okay, good. So essential parts of a power of attorney. So of course, the most important part is that you're going to actually name an attorney and an alternate attorney. And it doesn't just have to be one person. It could be 2 people and 3 people. I probably wouldn't go more than 3 just because that can make decision-making a little bit tricky. And this person will kind of generally have considerable power over your legal affairs, financial affairs, and your property affairs. So 19 years of age or older, and then also resident in Canada. So we run into issues with this quite a bit. So it may be that you want to appoint your spouse who lives in BC as your attorney, but then an alternate attorney, maybe it's a child that is resident in the US at the time. So that can create some issues just generally for proximity reasons. You want your attorney to be someone that's living nearby so that they can attend at the bank for you. And then also, if you appoint a US attorney, they may actually have to end up making US tax filings because of that. And then they also will probably have issues dealing with investment advisors as well. So just definitely something to keep in mind when you're considering who you're going to actually appoint. And the effective date, so your document can be effective immediately, which is what we recommend. So that means that it would be effective once you've signed it, and then also once your power of attorney, the person you've appointed as your attorney, has also signed. So that means that they would have the power to use that document right away. And then also the other option, which we find is not ideal, but sometimes works in certain scenarios, would be to have a springing power of attorney. And so that's a document that once it's executed by you and by your attorney, it wouldn't actually take effect until some sort of condition is met. Typically, that would be that you would have been declared incapable, and that would have been confirmed by 1 or more doctors. So that's a way of kind of protecting yourself from having somebody out there that has this document where they can access your financial affairs in particular. And then when we're looking at powers to give your attorney, generally you would give them the power to deal with your real property and invest your assets, hire like lawyers and accountants and investment advisors to assist them, and file taxes, and then also to use your property or your assets for your benefit, and then also for the benefit of your spouse and children. So of course, every power of attorney document doesn't need to have all of this, but generally, those are the powers that you would want to consider. And then just a note about what happens if you don't have a power of attorney. So that can create some issues. So if you, let's just say you were in an accident and you needed somebody to make legal or financial decisions for you, and there's no attorney appointed, then someone would have to make an application to be appointed as the committee of your estate. And so a committee application is a formal application with the court. So it can take a lot of time and it is quite expensive. So it's really not the ideal route to have to go through, especially if you need somebody to make those decisions for you right away. And then also anybody can apply to be your committee. So if you don't have a power of attorney in place, then you're kind of just leaving it open to anybody being able to apply to have this authority over your affairs. Okay, so that's powers of attorney. So if we look at the next slide, which is representation agreements. So this is a completely separate document, and this is a document where you would appoint a representative to have the ability to make medical and healthcare decisions for you. Essential parts are kind of similar. So you want to appoint a representative and an alternate representative. This person should also be somebody that you trust because they're going to be making or potentially making very important medical decisions for you. And it should be somebody that is capable of respecting your wishes. So it may be that even if you trust this person, you're unsure that they'd be able to respect your wishes in certain regards with medical affairs. So just something to keep in mind when you're considering who to appoint. This document can also be effective immediately, which we recommend, or it can be springing, so it could come into effect after you have become incapable and that's confirmed by a doctor. It will have like certain aspects of a representation agreement are pretty similar across the board or like across different firms. So it will generally provide your representative with the ability to make decisions regarding major healthcare and minor healthcare and personal care. So major healthcare might be something like making a decision for you or consenting on your behalf to major surgery. Minor healthcare might be just consenting to a doctor's appointment or a dental appointment. And then personal care could be maybe deciding where you're going to live or what your diet is or the clothing you're going to wear. And then generally, we'll also see a statement of your current wishes. So that will vary. And most firms will have kind of a standard set of current wishes for you to look at, but they can be changed. And of course, you don't have to even provide current wishes if you don't want to. But for example, our statement of current wishes says something along the lines of, if I'm in some kind of irreversible state, like maybe you're in a coma, and there's no reasonable expectation that you're going to recover, then you want to receive kind of medications to keep you free from pain, but you don't want to receive any kind of life-sustaining treatment. Okay. And then what happens if you don't have a representation agreement? So actually, under the BC Healthcare Consent Act, there's a list of people that medical practitioners will look to make decisions for you. So it's a long list, and a doctor would look to this list and consult with the first person available on that list. So it would be like a spouse, a child, parent, sibling, grandparent, and then just goes down like to friends, basically. So if you don't have a representation agreement, it's probably not the end of the world. However, you just don't have that assurance that you have appointed somebody that you want to make these decisions for you. You're kind of just leaving it up to, there's just going to be this list of people that could potentially make this decision. So it's better if you want to have that assurance that you have a representation agreement in place, appointing a primary representative and then an alternate or a couple of alternates. Okay. So that's planning during life. So those two documents would be in effect during your lifetime. And then after your death, they immediately no longer have any effect. So your attorney can't make decisions for you any longer. And then the will takes over as long as you have a will. So I guess generally we'll just discuss why make a will. One of the main reasons is that you want to appoint an administrator of your estate. So that's an executor or trustee. The benefit of this is that after your death, that executor will have your will and be able to start making decisions for your estate right away. They might not be able to do everything, but they can. It's like a document that provides them with the authority to start dealing with your estate right away. If you don't have that, there's really nobody appointed to do that for you. So there can be a delay. So you won't anybody able to kind of access, like deal with your banking matters and kind of get your estate rolling. There'll be a delay until a grant of administration is granted to whoever has applied to be the administrator of your estate. And then another reason is that the will allows you to appoint a guardian for minor children. So it's obviously a very important thing. So we would normally see this clause after you've appointed the executor, and you would generally say something along the lines of, if my spouse has predeceased me, then I appoint this person as the guardian of any minor children that I might have. And then if that person's unable, then this is the alternate guardian. So you have a little bit of a backup plan there. And so this is really important just because if you die without a will and you leave minor children, it may be that if you have a family situation where you leave a surviving spouse and that spouse, like if you just have like the classic family dynamic, that spouse is also acting as the guardian of your children, they will just take over. So it won't be very complicated in that case. But as family dynamics change and things are a little bit more complicated, that might not be the case. So you just want to make sure that you have somebody appointed to take on that responsibility. Otherwise, the public guardian and trustee and the ministry become involved, and there needs to be an application to have a guardian appointed. Okay. We'll just go back one more, actually. Another reason is that you want to be able to control the distribution of your estate. So in your will, you're going to be able to provide that you want your estate to be distributed in a certain way. If you don't have a will, you don't actually have that control, and your estate will be distributed in accordance with the laws of intestacy in BC. So similar to that, you want to avoid intestacy and also avoid the involvement of the public guardian and trustee in your matters. So intestacy, so that is when someone has died without a will. So we have to look to the BC Wills, Estates, and Succession Act to determine who can apply to be the administrator of the estate and who's actually going to benefit from the estate. So if you die leaving a spouse surviving and no children, then your estate will go to your spouse. If you die leaving a spouse and children, then household furnishings will go to your spouse. And then they will also get what's called a preferential share of your estate. So that could be like $300,000 or $150,000. And then the remainder, whatever's left over in your estate after all the debts and taxes, things have been paid, will be divided between your spouse, one share to your spouse, and then another share divided between your children. So that's obviously not what everybody wants. You want to have a little bit of control over how your estate is going to be distributed. Also, another issue with this is that if you die leaving minor children and they inherit, there's no trust terms set up for them. So let's say you leave maybe $100,000 to a minor child. The public guardian and trustee would become involved at that point, and those funds would be held in trust. And then when they turn 19, they would get that entire amount. So there's no real like protection for them. You may not want them to receive $100,000 plus interest when they turn 19, right? You might want to have a little bit of a staggered distribution so they don't get this huge lump sum of cash and can kind of blow it on whatever they want right when they turn 19. And then just if you have a will, it's going to ease the burden on your loved ones and friends because you'll have some kind of clear instructions set out as to what you want. Okay, next slide. Okay, so we're going to talk about essential parts of the will. So these are just parts of the will that we would generally consider. Some of them will, of course, be in your will. Some of them may not be in your will, but it's something that you do want to consider adding. So the executor and trustee clause will be something in your will. You want to appoint somebody to act as the executor and trustee of your estate. So they're the person that's going to actually deal with bringing in all the assets and making all the distributions and filing taxes. So because this is actually like it's a very time-consuming job and it can be quite complicated, you want this person to be trustworthy, honest, organized, responsible, and knowledgeable. They should also be an adult as well, and they should be resident in Canada. If they aren't resident in Canada, there are some different planning techniques you can kind of do to deal with that. But the issue is that if you've appointed one person as executor and let's say they're resident in France, there's like potential that your estate could also become a resident of France if they're dealing with all your estate matters from France. And the issue with that is that then your estate would have to file a Canadian tax return and then also a French tax return. So something that you want to avoid. And then also in regards to professional executors and trustees. So this is something that's becoming more and more common as family dynamics change and as people kind of disperse around the world. Not everybody has kids that live in Canada. So you could consider appointing a professional trust company. So that could be maybe like the most common ones we see are Royal Trust, Scotia Trust, Canada Trust. So they do typically have asset value requirements. So different with every trust company. So it's something to consider. And then they will also charge fees for taking on this role. Okay, so might not work for everybody, but it is a good backup option. And then, of course, you would see that guardian appointment clause. Just a note regarding who to appoint as well. So this person should obviously also be somebody that you trust. And you also want to consider their location. We've had some people recently with, they have siblings in Europe and they want to appoint them as a guardian, which of course you can do, but it's just something to think about. If both parents die, do you really want your child to uproot their life and have to move to Europe? And then there's also tax considerations there as well. And then also just consider that person's lifestyle and their circumstances and would they be able to take on the responsibility of being a guardian to the children. And then a personal effects clause. So that clause in your will can be pretty standard. You could just say something along the lines of, I leave all my personal effects to my spouse, and if they've predeceased me, all my personal effects are divided equally between my children. If you have specific gifts you want to give to anybody, you could also say that in your will. But we are using the what's called a letter of wishes more and more commonly. So that's actually a document that's kept alongside your will. So it doesn't form part of your will, and it's technically not legally binding. So it is just a statement of your wishes. But it does say, like, maybe it would say something along the lines of, in my will, I've asked you to divide my personal effects between my children, but I'd like you to consider these wishes, and then set out maybe a list of specific items you want to go to specific people. So not legally binding, but something that you can change whenever you want to. So it's kind of a good option. And then specific gifts. So you may or may not have this in your will, But if you want to leave a cash gift, you could do, like, for example, I leave $10,000 to my friend. And then you could also leave the same type of charitable gift if you want. We'll talk about that a little bit more on the next slide. And then the residue clause, so this is one that you will want to include. This is basically the residue of your estate is everything that's left over in your estate after all the specific gifts have been made, all the debts have been paid, and taxes and executor's fees, and lawyer and accounting fees. So everything that's left over in that estate pot, you will have to decide how you want that distributed. So typically it would say, your will might say, I leave the entire residue of my estate to my spouse. And if they've predeceased me, then equally between my children or their children if they've also predeceased me. And you might also will have a lapse of residue clause. That clause would just be kind of a worst case scenario clause. If everybody that you've named as a beneficiary has predeceased you, then you could leave a worst case scenario, then I want my estate to go to this person or to this charity. And then the last thing would be trust clauses. So there are quite a few options for these. The one we encounter most typically would be a trust for minors. So if anybody in your estate could potentially inherit when they're a minor, then there should be trust terms for them. Just providing that if they inherit, then their inheritance will be held in trust by the executor until they reach the age of 19. But it also doesn't even have to be the age of 19. We're seeing this more and more commonly, is that people like to increase that age. So if you could leave your inheritance to maybe kids or grandkids, but that it will be held in trust until they reach the age of 30, for example. And there could also be some sort of staggered distribution. So we're seeing that a lot where funds are held in trust until the age of 30, but maybe at the age of 25, half of the funds are paid out to that child so they can, pay for any kind of like education or property or car or something like that. And then the remainder paid to them when they reach the age of 30. And then we also could have trust terms for potentially disabled beneficiaries. So that would be beneficial in a situation if a beneficiary is receiving disability benefits. If they are going to inherit a big lump sum of money, that might force them out of the disability benefits program. So if those funds are held in trust, it would protect them from being like kicked out of that program. And then also spendthrift trust. So that's a trust for if you have a beneficiary that could potentially spend all the money once they inherit, or maybe if they have some substance abuse issues, you might have a trust for them just to protect their inheritance. Okay, so the next slide is in regard to charitable giving. So in your will, you have quite a few different options about how to make charitable donations. So you might see a specific gift. So again, that would be maybe you leave like $20,000 to a charity. It could also be a portion of the residue of your estate. So it could be I leave 25% of the residue of my estate to this charity, and then the remainder to my spouse or children. Or it could be a portion, or in some cases, the entire lapsed residue. So that's that worst case scenario. If everybody has died, then maybe you want to leave your estate to a charity. And so the benefit of this is that the charity can issue an official donation receipt after that gift is made. And your estate can then use that to claim the charitable donation tax credit when they're filing their taxes. So as part of your estate, your executor will be required to file tax returns for you. So they have to file all kind of like overdue tax returns, and then also a date of death return, and then estate returns as long as the estate is active. And so that date of death return is typically the largest tax bill that any individual will have. just because you're deemed to dispose of your assets when you die. So the charitable donation tax credit can be really helpful there because it can actually reduce the amount of tax that your estate is going to pay. And then just some tips here that you want to make sure that the charity is properly named in the will. So if you just Google CRA list of charities, a website will come up and you can search the charity and find their proper name and also find the charitable registration number. And you want to make sure that the charity is actually a registered charity or other qualified donee. That's just to ensure that they can issue the official donation receipts. And then just a note at the bottom here, this cypre or cyprise clause. That's a clause in your will that could be included if you've made a charitable gift. Then this clause would protect your estate if that charity wasn't still around at the time of your death. So it would just provide your executor with the power to make continue to make that charitable donation, but choose a charity that has a similar purpose as the one that you had intended to benefit. Okay. So next slide. Okay, so other considerations. I'll just go over this briefly because we're running out of time a little bit. So there will be assets that will pass outside of your estate, or in most cases there will be. So if you have kind of any registered accounts or pension plans, life insurance, if these have designated beneficiaries other than your estate, then those assets will pass outside of your estate. So they go directly to the beneficiary that's named, and your estate doesn't have to pay probate fees on those assets. Same thing for assets held in joint tenancy. If you own maybe real property jointly with a spouse and one of you dies, then that property will just pass to the survivor by right of survivorship. And then, of course, assets, if they're properly gifted prior to death, will pass outside of your estate. Funeral instructions. So we get asked this a lot, is if we should include funeral instructions in a will. And generally, I typically don't include funeral instructions. I just find that it's better to talk to your family members and your spouse and friends about what your wishes are for your funeral. Just because we find that when somebody's died, it's not usually the immediate first step to read the will. It sometimes takes a few days or a few weeks to even find the will. So by that time, likely there would have been decisions made already. So I think it's better to keep it out of your will and just discuss it with your family members, or some people even make the arrangements and pay for them in advance. So there's options for that. And then just planning in general, we recommend that your estate plan is at least looked at or reviewed every 5 or so years. But if your life circumstances have changed, then it definitely needs to be reviewed to make sure that it's going to reflect your current wishes and situation. So that may be if you got married or got divorced or had children, then you definitely should be taking a look just to make sure everything is still accurate. So protecting your estate. So in BC, under the Wills, Estates and Succession Act, a spouse or children can actually make an application to court to apply to vary your will. So this might occur in a scenario, let's say somebody has died and they left a spouse and children surviving, but their will provides that their entire estate should be divided between their children. So the spouse doesn't actually receive a share. So the wills variation provisions of the Wills, Estates and Succession Act allow that spouse to make a claim against the estate. So that would be a formal, like a court application. There would be evidence presented, and then the court would order whatever amount they think is adequate, just, and equitable in those circumstances after considering all the evidence. So they might order that the spouse gets a certain portion of your estate. And just a note here as well that it says spouse or children can make this application. So children don't have to be actually minors. It can be children of any age. So they can be adults. When it comes to options to try to protect this from happening, There are quite a few ways to kind of plan for it. One of them is to hold your assets outside of your estate. So that might be you hold assets in joint tenancy or with direct beneficiary designations or do some trust planning. So we won't get into trust planning just because it's kind of a whole thing in and of itself. But also what we typically do is we have a wills variation letter prepared. So that would be a letter that would also go kind of alongside your will. Doesn't form part of your will, it's a totally separate document. But if you are making a plan and you realize, maybe I'm not technically fairly providing for this person and they might consider making a claim, then you could have this will variation letter in which you would kind of explain all your reasoning for doing what you've done in your will. And it doesn't prevent that person from making a claim against your estate, but it would be submitted as evidence in the court action. Okay, let's see. So that's kind of generally what happens with your will. We'll just briefly go over what happens after death in the next slide there. So first thing that will happen is that your family members will determine if there is a will. Hopefully there is, and then the executor named in the will can start acting. So the executor will start working on identifying all your assets. So they'll find out what assets form part of your estate. So kind of maybe solely held bank accounts, things like that. And what assets won't form part of your estate. So assets that are held jointly or that have designated beneficiaries. And then they will likely hire a lawyer to help them prepare a grant of probate application. So as part of that, notices will be required to be sent out to all the people named in your will and anybody that under the law should have received a portion of your estate. And then after there's a waiting period there, 21-day waiting period, and your application would then be submitted to a probate registry. And the court kind of reviews the whole application and eventually assesses probate fees on the value of the assets that actually form part of your estate. So that's approximately 1.4%. After those probate fees are paid, the grant of probate is issued to the executor. And so that acts as kind of the confirmation that the executor has the ability to handle your estate. And then at that point is when the executor can take that grant of probate to banks and anybody else, give them a copy and let them know that they want to liquidate all the assets and deposit those into a bank account. And then from there, the steps will kind of vary depending on the assets in the estate and the will. But generally, then the executor will pay specific gifts, distribute personal effects, file tax returns, pay debts, and then once they're in the position to do so, they can make distributions from the estate. So it's not the shortest process, I would say. So I'm not sure how long the Victoria probate registry takes, but in Vancouver, it takes around 3 months for the court to even look at your application. So it is quite the process. And then when it comes to filing tax returns, that can take sometimes, maybe it could be a year if your estate is really simple, but generally I would say around 2 years before the estate is entirely wrapped up. Okay, so we'll move on to the last slide. So this is just kind of generally our key tips to take away from this presentation. So we obviously recommend that you have a power of attorney and a representation agreement and a will in place. But you should ensure that each person that you're appointing under those documents is aware that you've appointed them and that they've agreed to act. And you should also tell them where you're keeping those documents so that they have access to them if they need them. It's best to discuss funeral arrangements or funeral wishes with your loved ones and with your executor. And then it's also a good idea to keep some sort of inventory, which will help your family and your executor after your death. So you might be able to actually search online for some sort of template to fill out So a lot of people will kind of print a template, fill it in, and then keep it alongside their will. And it can list, just like keep a record of all your bank accounts, like maybe the beneficiary of your RIF or your life insurance, and then the name and contact details for investment advisors, accountants, lawyers. And then one other thing I didn't put on the slide, but I thought it was worth mentioning was in regard to the DIY will templates or online tools for preparing documents. We don't necessarily recommend that route. We find that they just really aren't specific enough. They can't really consider the complexities of your estate. Even if you think you have a really simple estate, generally there are some sort of unique things to consider. And they won't be able to take into account like tax planning, or maybe if you had a disabled beneficiary, things like that. So I think it's best to have a lawyer kind of consider your entire estate for you and draft those documents. Obviously that can be expensive. So one thing I sometimes recommend is that if costs are a concern, you may be able to find a smaller firm that will agree to a flat rate, which can be actually very nice because you know what you're getting into. So some firms out there might have a flat rate for a will, power of attorney, and a representation agreement. So just an option to consider. Okay, so I think the next slide has my contact details. So if you have any questions that we don't get to here, you can feel free to contact me. It's probably best by email. And then again, I'm in the Vancouver office here, but we do have a location in Victoria. So we can definitely pop over to Victoria for meetings. So we're available.
Wonderful, wonderful. Thank you so much, Sarah, for this wonderful overview of this crucial, very important topic, essentials of estate planning. We have a few minutes here for questions and answers. So I'm looking at the chat box, and there is a couple of questions that we have here. The first is, can you speak on the pros and cons on using a corporate POA versus a person or people?
I think maybe probably one of the pros is that usually like a corporate power of attorney is an expert in that area. Generally, they're available and they have professionals that can assist. If you have, like, for example, if you're appointing Royal Trust or any one of those major trust companies, in most circumstances, they will also involve their investment advisors, and the power of attorney document would allow them to do that. So it's kind of an all in one area type of a power of attorney planning, which is kind of nice. Major con would be the fees associated with that. So when you approach those trust companies, they will ask you to review a fee agreement, which will set out everything that they'll be able to charge you for their services. So it's generally not the cheapest way to go, but it is a good option. I think it's a good option, especially if you don't have anybody that you think will kind of have the knowledge or expertise to be able to handle investment decisions or dealing with real property.
Great. Before we go into the next question, I'm just going to stop sharing here the screen, Sarah.
Okay.
All right. So just let me take a look at the next question. Can you speak on the consequences on adding your children onto title on your home to avoid probate?
Sure, yeah. So that it's becoming a more common concern. I think in a way, I think all lawyers probably differ, and it's kind of like fact-based about your estate and what assets are in your estate. So it just generally speaking, I find it to be a little bit of a risky planning decision. So if you're adding a child to real property as a joint tenant, which was typically what would happen to avoid probate, then that child is an owner of your property. So if there's a creditor that comes after that child, not to say that's going to happen, but if there is a creditor, right, they can come after the property as well. So they could put a charge on the property. And also if your child is married or at some point gets married and then separates, then the property is also open to family law claims. So it is a little bit of a risk, I would say, considering the benefits. So 1.4% probate fees is technically what people are trying to avoid, right? So you want to avoid that the probate fees on the value of your property. But sometimes it may not be worth it considering the risks. And if I guess also taking into consideration the value of the property. So it's kind of a fact-based scenario, but it's definitely kind of a weigh the pros and cons. You might not be saving a ton after you've taken into account legal fees for putting the child on title. So definitely weigh the pros and cons there. And you can always give me an email if you want to talk about it as well.
And another question here, what is the difference between an enduring POA and a representation agreement?
So enduring power of attorney, so that's the document that will appoint somebody to handle your legal and financial affairs. The enduring piece of it is just the confirmation that if you were to become incapable, then that power of attorney document endures on. So it continues on and your attorney still has the power to act. And then the representation agreement deals with healthcare matters. So separate things. So it's almost like power of attorney, more legal, financial. Representation agreement or representative is more health related.
Perfect. And then there's another question here. I have family outside of Canada. Can I name Canadian residents as temporary representatives to look out for my assets and children?
Temporary representatives. I guess my concern would be that, I mean, you could put documents in place. It's always good to have documents in place. Let's say you have family members that will be moving to Canada, then the documents can be updated. But I think if you're going to name a Canadian resident as a representative or as an attorney, then I think you just have to be be okay with the fact that they could actually act. It may, you may have this temporary person appointed with the intention that they never act, but I think you need to be comfortable with the fact that they could act. And then if they never have to end up acting, then you can change it when you have family that comes to Canada. In regards to representatives, the representative doesn't necessarily have to be a Canadian resident. So it's a little bit different than a power of attorney. So we do have some people that appoint a child that lives in the US as a representative to make healthcare decisions for them. And that's generally okay, just as long as you're comfortable that they could be reached if they needed to make a decision. Hopefully that answers your question.
Well, I do have one question, Sarah, here. So if someone has assets in another province or even in another country, how should they approach estate planning to ensure their wishes are properly carried out? I'm thinking, are there specific legal considerations they should be aware of when dealing with cross-border or multi-jurisdictional estates?
Mm-hmm. Yeah, it's always best to have documents in place in each country or each jurisdiction where you have assets. So the law of BC is very specific to BC. So even if you have, let's say you have maybe a property in Alberta, we would say it's best for you to at least have a power of attorney in Alberta so that there's a document there that you know is actually going to abide by the laws of Alberta. And so that person can deal with your real property in Alberta. Your will is a little bit different. So if you your main residence is in BC and where most of your assets are held are in BC, then of course we want you to have a BC will. But there are some other options. So if we take that same example, if a person died in BC with a BC will, but had property or assets in Alberta, then the executor of your BC will would just have to take the grant of probate that's been issued to them here and have it resealed, basically go through the court process in Alberta to confirm that the will is a valid will, and then they can deal with if there's real property there, they can deal with it afterwards. So generally, best have to at least consult with a lawyer in each jurisdiction to make sure that you are putting proper documents in place.
Totally. And one last thing I was thinking about is, you did mention briefly about when you have an existing well. So if I want to update or make some changes in my well, do I need to create a new well from scratch, or is it possible to use what I currently have and make some changes to my current well?
Yeah. So you have both options, actually. If you're just maybe updating a name, maybe you want to change the executor or add a beneficiary, then you can make a codicil to your will. So that's an amendment document. So usually it's pretty short, and it's not as kind of a cumbersome process. So it can be a little more affordable than having an entirely new will prepared. But if you're making a lot of changes, or if you're making a change that you wouldn't, if you're taking somebody out of your will and you wouldn't want them to know that you took them out, then you should have an entirely new will prepared. Yeah, so we see that if you're disinheriting somebody, if you do that in a codicil, both of the will and the codicil will be publicly available. So then that person would be able to see, right, that they were disinherited at some point. So you have both options, and it kind of just depends what changes you're hoping to make.
Great. Wonderful. Thank you so much.
You're welcome.
Well, I don't see any other questions here. So are there any other final comments that you would like to share, Sarah, before we wrap things up here? Because I don't really see any other questions. So
oh yeah, and if anybody
wonderful.
has any kind of more specific questions that they don't want to ask in the public, feel free to email me, and I'll get back to you as soon as I can.
Wonderful. Well, thank you so much, Sarah, for this insightful overview of this crucial topic. And a big thank you to everyone who joined us today. I really hope you found this session helpful and that it provided valuable takeaways for your own estate planning journey. At Children's Health Foundation of Vancouver Island, we rely on the generosity of our community to fund 100% of our work. So if today's webinar has been helpful, or if you feel inspired by the impact we're making, I encourage you to visit our website, islandkidsfirst.com, to learn more about our work. And if you feel moved to do so, consider making a donation. Every contribution helps support Island Kids and their families. I'll be following up with an email containing some of the information that has been covered today, including Sarah's contact information for any further follow-up, as well as my contact information. If you have any questions, please don't hesitate to reach out if you have any questions or any inquiries, we'll be happy to help out. And once again, thank you so much for being here today. Wishing you all a wonderful rest of your day. And again, Sarah, thank you so much. Cheers.
Thanks, everyone.